Good day, everyone. Welcome back to our course, The Law on Sales, and we are now in part 4, fourth installment. Again, this is your host, your moderator, your instructor, and your professor, the lawyer, Lyndon A. Maceren. Okay, we begin our discussion today with Articles 1475, 1477, 1505, 1506 of the Civil Code of the Philippines. This is cases when a sale is made by a non-owner or is made by one having voidable title. So sale by a non-owner during perfection stage. So we're still in perfection. If the sale is made by an owner, it is valid. And if a sale is made by a non-owner, it's likewise valid. Why? It's still perfection stage. It is still perfection stage. The law does not require that the sale must be made by the owner. So here's the reason why both sales are valid, because ownership is necessary only at the time when transfer of title to the goods is made. So meaning that the seller must have the right to transfer title during the consummation stage of the sale. So at perfection stage, there is yet no obligation on the part of the seller to transfer the ownership. So again, there are three stages, the solicitation or negotiation stage, the perfection or birth stage, then the consummation stage. So owner is only, or right to transfer title is only required during the consummation stage. So we are still discussing perfection stage. During perfection stage, the law on estoppel further bolstered it. So if you admit something during perfection stage, if the buyer or the seller admits something, he is further estopped, meaning he cannot retract or refute what he has admitted. So title passes by operation of law to the grantee when the person who is not owner of the goods sold delivers it and later on acquires title thereto. Now, since valid, the action to annul is improper. So there is already perfected contract. Okay? So when it is made by a non-owner or a person with a voidable title. So who are persons with a voidable title? So minors. If a minor sells his asset, then it is voidable. Or those who cannot enter to contract because they have no legal capacity to sell or to enter into contract. Or those who are hypnotized or under the under the influence of alcohol. Voidable. But we are now discussing during consummation stage, the contract of sale is valid because it has passed the perfected stage, despite seller not being the owner or seller having no authority to sell. So it's still valid. So still valid, but what is void is the transfer ownership did not pass. So because the ownership, he cannot transfer it because he is not the seller. Now that is void. Okay, it becomes void. So effect, the buyer acquired no better right than the transferor, because he cannot transfer. So that's the legal effect. The buyer acquires no better right. So he acquires the title of the transferor. And the legal effect, caveat emptor, meaning buyer beware. So whoever buys should be exercise caution. No? So sale of co-owner of whole property or definite portion. So this applies to sale of a co-owner of the whole property or the definite portion. Because a co-owner only owns a portion of the whole property, so not the entire property. So this happens when a co-owner sells the whole property without the consent of the other co-owners or without the authority of the other co-owners. So general rule, when this happens, the co-owner sells the whole property prior to partition. No? Then the sale of property itself is void, but valid only up to the share of the co-owner. So when does co-ownership happens? Co-ownership again happens when a property which is undivided is is owned by numerous persons. So again, when a property, undivided property, is owned by numerous persons. This happens when, for instance, when a person uh, owns a property and this person has many children. No? Let's say he has 5 children. Then suddenly he dies. So what now becomes of the property? Who owns his property? The property is now passed on to the heirs, to the 5 children. So now the children are the co-owners by operation of law. They are now co-owners among to each other of the whole property. It's still undivided. Now one of them decides to sell the property without the authority of the others. So what happens? So this is now what happens. The co-owner sells the whole property without being divided yet. So it's still whole, it's not partitioned, so it's still intact, no division made. So the sale of the property itself is void, but it is valid as far as the co-owner is concerned. So if he is, there are 5 of them in our example, so what is valid is only 1/5 of the property that's being sold. No? So 1/5. Now the co-owner sells definite portion to the partition. So meaning his share to the property. So if his share to the property is 1/5, so that is the definite portion that he this another one when a co-owner sells the definite portion to the partition. So he thinks that this is his share. Let's say the property is divided into 5, so 1/5. So he thinks that his share is here located in the north side near the road. Let's say there's only one road that traverses the north side. So the general rule is the sale is void as to the other co-owner, but valid as to his spiritual share. If the buyer would have still bought such spiritual share, had he known that the definite portion sold would not be acquired by him. So this is the general rule. When a co-owner sells definite portion to the partition. So again, it is void as far as the other co-owners are concerned. But as far as the seller is concerned, it is valid as to his share. No? But there are exceptions to the rule on the effect of sale of a definite portion by a co-owner. So, number one, the subject matter is indivisible by in nature or by intent. Number two, when the sale of a particular portion of a property is with consent of the other co-owners. So, this is the exception to rule number two. So, when the subject matter is indivisible in nature or by intent. So, let's say, for instance, the property is a car. So, it is indivisible by nature. You cannot divide a property 1/5, or you can have the engine. So, as far as the co-owners is concerned, this is valid sale because he's a co-owner. You know? And the sale, number two, is the sale of a particular portion of property is with consent of the other co-owners. So, no question, there's consent made from the other co-owners. Then the co-owner, who is the seller, sells one of two commonly owned lands, does not turn over one half of the proceeds. Then the other co-owner, by law and equity, has exclusive claim over the remaining land. So this is very clear. When a co-owner, meaning there are only two of them, sells one of two of commonly owned lands, does not turn over one half of the proceeds to the other co-owner, then by law and equity, meaning by fairness, the other co-owner has exclusive claim over the remaining land. So there's another one remaining. Yeah? The co-owner only sells one of the two commonly owned lands. So there's one remaining. So the other co-owner can claim the remaining land, which is the one. I will discuss the rules on legal effects of sale by a non-owner. So the general rule, when the sale is made by a non-owner, the buyer acquires no better title than the seller. Okay, so meaning he acquires the title of the seller, but not better than that. Only the title of the seller. Whatever the title of the seller is, then he acquires it. If the seller is not the owner, then he becomes also not the owner. Exceptions. The owner by his conduct is precluded from denying seller's authority. So meaning the owner has already given the seller the authority to sell, and by his conduct is precluded from denying the seller's authority. He is stooped. And this happens when the owner admits to the buyer that yes, Mr. Seller here, even though he is not the owner of the land, I have given him authority to sell it. So when the owner made such declaration in front of the buyer, then he cannot deny anymore the right of the seller or the authority of the seller to sell the property. Number two, contrary is provided for in recording laws in the Presidential Decree 1529. So when the title has been recorded already, then you cannot deny it. No, it has been, if it has been titled in the name of the buyer. So meaning the owner can no longer recover it because it has been titled. This is the recording laws. So the question, how did the buyer recorded it? Sale is made under statutory power of sale or under order of the court of competent jurisdiction. So this is another exception. So when the sale is made under statutory power of sale, meaning there's a law that states that the owner must sell. This happens when there is expropriation. There's an order by the court that you have to sell it. And now the sale is made by the power of that order given by the court. So the owner of a property in expropriation proceedings, or what's that power? The power of eminent domain cannot deny the authority of the state. If it is the state. But if it's a local government, then they're still subject to evidence, meaning the local government has to prove that it needs the property for public use. But when it is the national government, like the DPWH, then there's no question about it. Number four, the sale is made in a merchant store in accordance with the Code of Commerce and special laws. So even though the owner of the store is not the owner of the product which is being sold in the merchant store, then the sale is still valid. The example of this, when you happen to leave your shoes, left your shoes there in the store of an owner, which is owned by another person, then somebody, a customer saw your shoes and liked it and wants to buy the shoes. The owner of the store I do not own these shoes. If the customer wants to buy the shoes, then okay, go ahead, you buy it. So how much? There's no price tag. Okay, I'll sell to you for 1,000 pesos. And there's no question. Why? Because it's a merchant store. According to the law of sales or Code of Commerce, whatever is found in the store and it's sold now belongs to the buyer. Okay, we will now discuss the sale by seller with voidable title, meaning this is sold by minors, insane persons, etc. Okay, during perfection stage, the sale is valid, meaning the buyer acquires title over the goods. Now we go to consummation stage. Seller has voidable title. It's still a valid sale if the title has not yet been avoided, meaning the title of the person selling is still not declared voidable. Still not declared void because it's voidable. So the buyer buys goods under the following condition. This should be in the condition of the buyer that he must be in good faith, meaning he does not know of any flaw on the part of the seller, meaning he does not know that the seller at the time was insane. He does not know at the time that the seller was hypnotized. So buyer must be in good faith and for value and without notice of the seller's defect of title. So without these three, he'll become a buyer in good faith, so the title of the property will not pass on to him. Now let's go to movable properties. So in movable properties, whoever possesses the movable property is equivalent to title. So general rule is possession is equivalent to title. So if you are holding the motorcycle, if you're using it, you're possessing it, then the general rule is that it is equivalent to title. So what are the requisites the possession of the movable, and you are in possession of the movable, meaning the person is in possession of the movable, and that possession was acquired in good faith. So there are two requisites. There are the exceptions. Owner lost movable. Then owner can recover without reimbursing the price. So if the owner lost it, he can still recover it without reimbursement of the price, without reimbursing the price to the whoever is the possessor. Yeah. Let's say the owner lost the motorcycle. Somebody found it. Then the one who found it sold it. So the owner found the motorcycle in possession of the buyer. So what's the rule? The owner can recover without reversing him the price. So whatever he has paid, or whatever amount he has paid to the person who found the motorcycle, then he has no right to be reimbursed. Number two, owner is unlawfully deprived. When it happens when the owner of the motorcycle has been robbed, no, or under has been compelled to give up possession of the motorcycle because he is at gunpoint. Tiunan siya pusit. Then the owner in this also can recover without reimbursing the price. It's still the same. But if the movable is bought at public auction, then the owner can recover only when he reimburses the price to the one who possesses it. And acquired in good faith and for value from auction. Because in auction sales, once the hammer bangs, even though the auctioneer is not the owner, then it is valid sale. Yeah. So this happens when you mortgage a motorcycle, and or you pawn your motorcycle or your car, you mortgage it. So without paying the loan, then the the bank or the mortgagee can sell the property now in public auction. So the recovery, if the owner wants to recover the property, then he has to reimburse it, and it's subject to expiration. You know? Okay, now we discuss articles 1493 and 94. This is loss or deterioration and the fruits and other benefits of the property. So legal consequences from point of perfection are the same in both legal systems. Upon perfection of an unconditional contract of sale involving specific or determinate subject matter, the risk of loss, deterioration, and the benefits of fruits and improvements were for the account of the buyer. So it means that if the thing is sold, or if the thing has been properly sold during the perfection stage, at the point of perfection, even if it is specifically unconditional contract of sale and the subject matter is specific or determinate subject, then if it is lost, then the risk goes that to the buyer. The risk of loss or determination is that to the buyer. Or if it has fruits and improvements, then those fruits and improvements will now go to the buyer, even if it is still at the point of perfection. Okay. So let's say, for example, you're buying a pig, and the pig at the perfection of sale is pregnant. No, it's got a small piglet inside the womb, but you do not know. So, and then you bought it today, November, let's say November 16, November 1. 5 days, and delivery would be made on December 1. Let's say 30 days from now. But before delivery, on November 15, the pig delivered. The piglet was born. No, so 15 days from the date of sale. So who owns now the piglet? So according to this article 1493 and 44, whatever is uh, the fruit and improvements to the thing during the perfection of the sale, meaning not yet consummated, is to the buyer. So the buyer now owns the piglet. So who bears the risk of loss, deterioration of the fruits? So before perfection, of course, before perfection, then the res perit domino, so it is owned by the owner. Owner is the seller, so seller bears the risk of loss, no? Because it is owned uh, still owned by the owner. So at perfection, the contract is merely inefficacious because loss of subject matter does not affect the validity of the sale. So if the thing is lost and there was already perfection of sale, so who bears the loss? According to the rule, it's the buyer. And since the thing is already lost during perfection stage or after the perfection stage, so meaning the seller cannot anymore comply with the obligation. So he cannot deliver it to the buyer anymore. Therefore, the buyer also cannot anymore be compelled to deliver the price. So, in other words, the sale is cancelled, no? By operation of law when the thing is lost or deteriorated at perfection stage. But if the thing is lost after perfection but before delivery, so this is the point where the thing is lost after the buyer and the seller agreed and before delivery. Then if it is lost, then it, it could it is confused state, no? According to the authors, Justice Paras, the buyer suffers the loss. According to Tolentino, another author, it is the seller who suffers the loss. And they have different opinions. So this is confused state. So deterioration and fruits, the buyer bears the loss after the perfection sale, after the perfection but before delivery. So if you answer the buyer, it's still correct, but you have to support it. If you answer seller, it's still correct, no? Because authors are confused in this state. But if the thing is lost after the delivery, then whoever owns the property now suffers the loss. This is res perit domino. Who owns the property will suffer the loss. So delivery extinguishes ownership vis a vis, then the seller creates a new one in favor of the buyer. So after delivery, the ownership of the thing is already transferred to the buyer. So if it's lost, then the buyer will suffer the loss. Okay, now let's go to now the remedies of parties for breach of contract of sale. This is the breach of contract of sale uh, found in Articles 1594 to 96, then 1484 to 86, and 1592. First, we discussed when the subject matter is movables, meaning uh, movable property or personal property. There's a breach of contract of sale, meaning it's either the buyer or the seller committed the breach. So if it is made by the buyer, the seller is unpaid. So who is an unpaid seller? You should know that, no? So any man may take law in his own hands, must seek a remedy through the courts. So the unpaid seller has the right to uh, take it to the court and file a complaint against the buyer. So specifically for a specific performance, meaning to demand payment, or if not, to rescind the contract. Then the doctrine of self-help, if he can still do something without the aid of the court, then that's an exception. And other would be special remedies, and these are the requisites in order to perform these exceptions. The requisites, the subject matter are goods, the seller is unpaid, not completely paid, or receive a negotiable instrument under the condition, and a condition has been breached by reason of dishonor. So no funds, meaning the instrument, let's say for example it's a bill of exchange and it's been dishonored. Bill of exchange, the payor is a different person, no? Another one issues, is given to the payee, and the payee now presents it to the pay to the one who is obligated to pay, and it is dishonored because no funds, no, like a check for instance. The bank is the what is the title of the bank in negotiable instrument? Issuer, holder, and the drawee, the drawee. So the drawee, the bank found out that the person has no, or the drawer has no funds in his in the bank. So, syempre, what happens to the negotiable instrument is dishonored. Third, the physical possession is with the seller. So the goods are still with the seller. So if it's doctrine of self-help or other special remedies, this is very important. The seller is still in possession of the goods, and the goods have not been paid or paid, but the negotiable instrument that has been paid, that has been issued, has been dishonored. The following are the special remedies of unpaid seller. These are the remedies of the unpaid seller. Possessory lien, meaning he has a charge of in the possession. Now he can possess the property. If he still has it, then he has the right to possess it. Or if its agent of the seller is still in possession of the goods, then the seller can instruct the agent to hold it for him. No? But if the goods are already passed on to the buyer or to the agent of the buyer or to the shipper or the shipping company, it's now in transit, so the remedy of the unpaid seller is stoppage in transito, diba? To stop the delivery of the items or the goods. That is stoppage in transito, the right of stoppage in transito. And number 3, special right of resale. If the goods are what do you call it, perishable. If the goods are perishable, then the seller has the right to resell it to somebody else. Otherwise, the goods will lost its value. Then the seller has special right to rescind. Yeah. Rescind meaning to cancel the sale and then repossess the goods. So hierarchical application. So only when unpaid seller has exercised possessory lien or stoppage in transito can the seller proceed with his other special rights of resale or to rescind. No? So this is hierarchical application. So meaning it should be 1, then 2, then after he can possess these 2, then proceed with 3 or 4. Okay? The seller cannot go to 4 directly. So it should be hierarchy. Okay. So possessory lien, the seller is not bound to deliver if buyer has not paid him the price. So, okay. If it's still with the agent, do not deliver it to the buyer. He has not yet paid the price. So right to retain, meaning cannot be availed when the seller does not have custody. So that's the requisite, no? To exercise possessory lien, the seller must have custody of the goods. Exercisable only in following circumstances: the goods sold without stipulation as to credit, the goods are sold on credit but term of credit has expired, then buyer becomes insolvent, and when part of goods delivered may still exercise right on goods undelivered. So there is portion of the ordered goods have been delivered and some of them has not yet been delivered. So when are the instances when possessory lien is lost? So we're still discussing possessory lien. Number 1, when the seller delivers goods to the carrier for transmission to the buyer without reserving ownership in goods or right to possess them. So this happens when the seller delivers the goods to the carrier, and the condition is shipping point, no? Free on board shipping point, meaning it's the buyer who pays the cost of the freight or the cost of the transportation. In that case, the goods have already been transferred to the buyer. Diba? Shipping point. But if the goods had been delivered to the carrier or to the shipping company and he has reserved his ownership, meaning it is shipping delivered free FOB destination. So meaning it's the seller who pays the the fare. So he has reserved his ownership. So he has rights to possess them. Number 2, when the buyer or his agent lawfully obtains possession of the goods. So let's say the shipping company is the buyer's agent. So when I say when the seller delivers it to the shipping company, FOB shipping point, then the shipping company becomes the agent of the buyer. Or when there's a waiver issued by the seller of the goods. So he will lose his possessory lien. The seller also loses his lien when he parts with the goods. Still has stoppage in transito though. No? When it is already delivered to the shipping company, however, he has already lost it, the possessory lien. But he can exercise his stoppage in transito. And number 5, notice by seller to buyer is not essential in this possessory lien. So let's go to stoppage in transitu. When can it be exercised? This is exercisable when happens when the goods are in transit, meaning still with the shipper or still with the deliverer. Let's say you are delivering the goods by a Lala move, no? And then you can still call the Lala move. Hey, Lala move, do not deliver. Why? Because the buyer did not make good of his check. It bounced. Okay. You can still deliver it, but collect the price directly from the buyer. So these are the requisites when the goods are in transit. So number 1, from the time goods are delivered to the carrier or the shipping company for purpose of transmission to the buyer. So it's still with the carrier. Then the goods were rejected by the buyer, and the carrier continues to possess them. So these are different. No? This happens when the goods are still with the shipping company because they were rejected by the buyer. So the seller can then exercise his stoppage in transitu, the right of stoppage in transitu. So when are the goods? These are the requisites where the goods are in transit. No? Okay. The time the goods are delivered to the carrier, and the time the goods were rejected by the buyer, the carrier continues to possess them. So goods are still in transit. So when are the goods deemed to be no longer in transit? Number 1, when it has reached its point of destination. Number 2, before reaching destination, the buyer obtains delivery of the goods. How is that? When I said it is shipped on the condition of FOB, shipping point. No? Number 3, when the goods are supposed to have been delivered to the buyer, but the carrier refused. Oops, this time it's the carrier's fault. No? And number 4, it's shown by seller that buyer is insolvent, failure to pay when debts become due. So when the buyer during the in transit, the buyer becomes insolvent. Then he fails to pay his debts when they fall due. So the goods are no longer in transit. So how does the seller exercise his right of stoppage in transitu? We're still in the right of stoppage in transitu. So how can the seller exercise it? Number 1, obtain actual possession of the goods. Give notice of claim to carrier or bailee in possession of the goods. The notice by seller to the buyer is not required, but notice to carrier or the shipping company is essential. So the seller must then actually possess the goods by calling the shipping company or the bailee in case of warehouse, no? Or the carrier or the delivery man. So it must notify him. Do not deliver to the buyer. But the seller did not notify the buyer. The law does not require. Okay. And let's go to reselling the goods. This happens when the goods are perishable. So the right of the seller to resell it is immediate, no? Then, when it is stipulated in the right of resale in case buyer defaults in payment. So there's a stipulation in the contract. Then buyer in default is for unreasonable time. So, dugay na kayo. The notice by seller to buyer is not essential. So there's only three. No? This one is as far as notice is concerned. So in a right to resell, this is special because there are things which the seller cannot do in ordinary sale. It's a different situation because the ownership is still with the buyer, but the seller can sell the goods. This is the right of resale. So it's special kind of sale. The title according to buyer is destroyed even without court's intervention. So because of the condition of the buyer, he's insolvent, he did not pay, so that would happen or take place. No? Now let's discuss the special right to rescind on the part of the seller when it is expressly stipulated or provided in the contract. Then the buyer is in default for unreasonable time, meaning for 3 installments. Unreasonable na. The notice needed to be given by seller to buyer. So if it is a special right to rescind, then there is notice necessary on the part of the seller to the buyer. So why again this is special? Because ownership of the goods is already with the buyer, but the seller may still rescind it. And the ownership is destroyed even without court's intervention. But in ordinary sale, the seller need not go to court to destroy transfer of ownership. So remedies of the buyer when the seller fails to deliver. So let's go to the buyer. So that's for the seller. No? Now let's discuss the remedies of the buyer when the seller commits the breach. So the seller fails to deliver the goods. So what's now the remedy of the buyer? The buyer may seek specific performance without giving seller the option to retain goods on payment of damages. So specific performance, that's to demand the seller to deliver, and you have no more option to retain the goods, and you have to pay damages. No? So those are the remedies of the buyer. Okay, let's go to installment sales. This is provided for in Article 1484. So what is the remedy of the seller in case the buyer defaults? Payment, because it's installment sale. So number one is to exact fulfillment. That is to demand from the buyer the payment. That's number one. Number two is to cancel the sale if the buyer fails to pay 2 or more installments. Let's say the goods sold here is a motorcycle. The buyer fails to pay 2 or more installments. Then cancel the sale. That's the remedy of the seller. Then foreclose the chattel mortgage. If the buyer fails to pay 2 or more installments, then foreclose the chattel mortgage. The chattel mortgage is on the goods, or the good, or the motorcycle. So, if the buyer chooses foreclosure, there's no further action against buyer to recover any unpaid balance of the price, because this is alternate remedies. No, if the buyer chooses number 2 and 3, Oh, number three, foreclose the chattel mortgage, then he can no longer proceed with number one and two. It's in the alternative. If the buyer, if if the seller, we're talking about the seller. If the seller demands fulfillment, then he must stuck to fulfillment first and wait for the buyer to pay. So when is the law applicable? It's the sale on movables by installment, or the recto law. No? So this is payment by several partial payments in small amount. So the rationale of the law is that the buyer is lulled into thinking that he could afford because of small amounts per installment, and at the same time remedy abuse of commercial houses. So the nature of remedies is in the alternative and not cumulative. So the coverage, sale and financing transaction, and contracts of lease with option to purchase. So this is the coverage, no? Sale and financing, and contracts of lease with option to purchase. The action required could be judicial or extrajudicial. So judicial is in court, extrajudicial is outside the court. So specific performance. This is exact fulfillment. If already chose specific performance, meaning if the seller already chose specific performance, he can no longer choose the other remedies. Except after choosing, it has become impossible, meaning the buyer is still defiant in paying the installment, then rescission may be pursued. So rescission happens if it is chosen. There is correlative obligation to restitute, meaning to restore whatever the seller has received. But stipulation that installments paid are forfeited are valid if not unconscionable. So whatever the buyer has paid or any installments paid can be forfeited if it is stipulated in the contract. And it may serve as renting the property. So let's say if you bought a motorcycle and the monthly payment is 4,000 per month. You failed to pay more than two installments. So now the seller chooses altered option number one, that is specific performance demand payment from you, and still you're defiant to pay. So now rescission is being sought by the seller to rescind the contract. But there's obligation to restitute, meaning to restore in rescission. No? Iuli. But if there is stipulation, so it can be stipulated in the contract that whatever the payments that you have made in case of rescission shall be considered as rental to the goods. So it be now forfeited in favor of the seller. So seller now has no right to restitute or restore whatever payments you made because they are deemed as rental of the goods. Okay. So deemed chosen when notice of rescission is sent, takes possession of the subject matter of sale, then files action for rescission. So the barring effect of recovery of balance. Okay. So if the seller chooses foreclosure, barring effect meaning the seller can no longer recover the balance. No? If the seller chooses the remedy of foreclosure, meaning taking the chattel mortgage, which is the goods itself, now there is a barring effect on recovery of the balance. So the seller can no longer demand payment of the balance. Then extent of the barring effect up to the purchase price. So cannot demand. Exception, if the mortgagor refuses to deliver the property to effect foreclosure. So recover also expenses incurred in attorney's fees, etc. Perverse buyer mortgagor. So a buyer is perverse when he does this. He refuses to deliver the property to effect the foreclosure. Even though he's not paid the installments, he still uh, withholds the property. Okay, let's go to immovables or real properties. What are the remedies of the seller in case of breach on the part of the buyer? So anticipatory breach on the part of the buyer, the seller, number one, has reasonable grounds to fear the loss of immovable sold at its price sue for recession. So here the seller has anticipated that he has reasonable grounds to fear loss of the property and the price, so he may sue for a recession. Then, in case of non-payment of the price, he should also sue for recession. No? So these are uh, different scenarios. The first, there's a ground, and now there is non-payment. So the remedy is recession. First is recession, and the second is recession. What about the buyer? What are the remedies of the buyer in case the seller defaults or does not deliver the goods? So in case of subdivision or condo projects, the buyer can suspend payment. Let's say, for instance, the condo project, there's no road yet. There's no road network. It's just a plan presented to the buyer, and the buyer is almost halfway in his payment. No, let's say 5 million pesos, and now I'm already halfway. I paid 2.5 million pesos. You still have no roads. You got a building, but there's no road. Then the buyer can suspend the payment. Or you have a building, but there are still no rooms or no elevators, then suspend payment. Number two, if the real estate developer fails to comply with the obligation according to the approved plan, then the buyer can rescind the sale or suspend payment until the seller complies with the obligation. So removables by installments, this is in Article 1592. So applies only to contract of sale. The law that applies here is the Maceren law. While in movables or personal properties, the law is the recto law. So the Maceren law applies to contract of sale and contract to sell and financing. So there is installment. So the coverage when the subject matter is a real estate or a condo, no? So defined space, real estate, and condo is not defined space with common area. Excluded from the law is the industrial, commercial, sale to tenants under agrarian laws. Tenants, mag-uma ba? Mag-uma, no? So these are not covered by the law. So what are the rights granted to buyers? When buyer has already paid at least 2 years installment, 2 years installment, these are the rights. Number one, pay without interest the balance within grace period of 1 month for every year installment payment. So since he has already 2 years, then for every year the grace period is 1 month. So meaning he has 60 days not to pay interest, no? if he has missed installment. The grace to be exercised is once only every 5 years. So he can exercise this right once every 5 years, meaning he can have a grace period of 1 month for every year of installment without interest. No? So when no payment is made, then the sale is cancelled. What happens? The buyer is entitled to 50% of what he has paid. Plus, if after 5 years of installments, he is entitled to 5% for every year, but shall not exceed 90% of the total payments made. So again, if the buyer has stopped installment, then and he has paid more than 2 years, so the rule here says that the seller can cancel the contract, but the buyer is entitled to 50% of what he has paid. And if the buyer has already made installment of more than 5 years, then for every year of installment he is entitled to 5%, but not to exceed 90% of the total payments made. And number 4, cancellation to be effected 30 days from notice and upon payment of cash surrender value. So this is the cash surrender value, 50% plus 5% for every year of installment, but not to exceed 90%. Okay. So what if the buyer paid less than 2 years installment? What are the remedies of the buyer? So the grace period is 60 days from date of installment become due. He has a first grace period of 60 days. Then second grace period of 30 days from notice of cancellation or demand for rescission. So less than 2 years, the seller can give grace period to the buyer for no interest for 60 days. Then if it's cancelled, then he be given 30 days notice of cancellation or demand for rescission. So he has still 30 days to pay the installment, no? Make good of his payments. So see, buyer can still pay within 30-day period, even though there is such notice given, of course with interest, and if no payment after 30-day period, then the seller can cancel. The purpose of the law is to protect buyers in installments against oppressive conditions. Notice is needed. So meaning the seller must notify always. Waiver is oppressive. So there is no waiver applicable in this law, the Maceren law. So this applies to contracts even before law was enacted. So this is retroactive law. No? The stipulation to contrary is void. Okay. So if there's a stipulation in the contract that Maceren law will not apply, that is a void stipulation. So other rights of the seller, this other rights, the buyer can sell rights to another. If he has no more money to pay, then he can sell his right. Meaning he can reinstate the contract by updating during grace period and before actual cancellation. Then he has deed of sale to be done by notarial act. No? So he can sell it to another party. So he has the right to do that, as long as it is within the 30-day grace period. Okay. Then to pay in advance in installment or the full balance of price anytime without interest. and have full payment annotated in certificate of title. So when there is a notice of recession, then the buyer can look for uh, another person to assume, no, assume his contract, his obligations. And now once he finds a person who will assume his obligations, then that person has then to pay. He can pay in advance installment, and or he can pay full payment, which should be annotated in the certificate of title. Okay. So in case of recession of contracts covering immovables, as stated in Articles 1191 and 1592, the remedy of recession can only be exercised in court, meaning you have to file a judicial petition in court. No. So extrajudicial recession is allowed if it is stated in the contract. Okay, if it is stated in the contract, but if it's not stated, then it should be judicial. Then the court still has final say as to the propriety of the recession if it is extrajudicial. Then forfeiture of amounts valid being of nature of penal clause. Okay, so whatever the buyer has paid in installments, then it can be forfeited as a penal clause, no, in behalf of the owner or the seller. Okay. So when is this applied or applicable? The recession. Recession is applicable in contracts of sale, contract to sell. It is not applicable because there is no transfer yet. Because non-payment of purchase price would automatically cancel even without further action of recession. In contract to sell, there is no sale yet. So that's why recession is not applicable. This is only except if the subject matter is residential lots. Law on recession applies when there is substantial breach. So therefore, Maseda law applies. But you have to define what substantial breach is. Alright. So that ends part 4 of the law on sales. So we have discussed the Maseda law, the recta law, remedies of the buyer, as well as that of the seller if it's unpaid seller. So if you have any questions, clarifications, or any suggestions, you write me. My email account, Maceren and macerenlaw@gmail.com, or chat me in my MS Teams account or Facebook. So continued learning and have fun because knowledge is power.